Welcome to Notable Approvals. I am attorney Amanda Shaffer. Before I get to another marathon case today, first I want to remind you, don't forget to like us and follow us on Facebook and Instagram and YouTube and LinkedIn, all of that, so you don't miss any of our other lives. Oh, got someone to wave to. In addition, if you feel that this video has been helpful for you or any of our others, please share it with family and friends or anyone you think may find use out of it. And last announcement for today is tomorrow we will be having episode number 9 of Are You Smarter Than a Naturalized Citizen? We have 2 new contestants, the Battle of the Franciscos, who will battle it out to see who can pass the naturalization test first. That will be tomorrow, 9 p.m. Eastern, also on Facebook Live, YouTube Live, and on Instagram Live. If you go to our Facebook page, you can go to the event page, learn more about our contestants, and also see our new wall of winners that went up. And if you have any questions about that, or anything I talk about here today, our contact information will be scrolling along the bottom of your screen for the entire time. Well, of course, the second I start this, the client who's coming calls. Hold on one second, I got to do this. The Shapiro Law Firm, how may I help you? Oh, you're here. Okay, give me 2 minutes. You're a little early. Okay. Got someone waiting, so I'll do this quickly. So this client is a native and citizen of Mali, and he's actually been our client since before I was even a lawyer. I was still in law school when he first hired Aaron to represent him at a Stokes interview, which is where the interview where you and your spouse get separated and they ask you the same questions to see if you can get them right. So he came to us, well, not even me, because I wasn't here till 2012. Went to Aaron in 2011, and unfortunately, his wife abandoned him 3 days before his Stokes interview. Now, I forgot to mention that he entered the U.S. as a student on a student visa in F1 back in 2002 and attended school up until 2009. That was also the same time that he married his U.S. citizen wife. She then filed for him, and the interview was in 2011, but she didn't show up. So it got denied. And when it got denied, he was then placed into removal proceedings pretty soon after the I-130 denial. So at that point, he didn't even know where his wife was. He was in a bad spot of, well, how am I going to stay in this country? Well, he then told us, and I think at this point, still wasn't there, because I was on his case later on. So at the end of 2011, he started to tell Aaron, well, I can't go back home. And the more we talked about it, we realized that since he married the U.S. citizen and his family found out, they've been threatening him to the extent that he would have been very badly injured or even killed if he went back, because they had already arranged a person for him to marry, and he went behind their backs and got married. And you hear this a lot about women, but men have these issues too. And he even had a cousin who, shortly before he filed for asylum, had the same issue and went back home and was actually poisoned. So even though this was well after a year since he came to the U.S., so he would not qualify for asylum, but he still would qualify for withholding of removal, which means he could stay in the U.S., he won't have to return, he has to have a work permit to work, and he can't get a green card that way. But look, that's a better option than being killed, obviously. So he wanted to do it. So we filed for his asylum, and it was based on his membership in a particular social group. It was also cultural, based on how Malayan men are seen in society and their family. In the Trump years, we probably would not have, maybe we would have filed it, but it wouldn't have gone very far, because They changed the meaning of a particular social group, but if he were to have to deal with it today, if he came to us, there's a good chance we could show how the family unit what is a particular social group. But that's for another time. So he filed for asylum, and then it gets referred to the court because he was here. He filed it more than a year after he arrived in the U.S., so they couldn't approve it anyway. In 2015, he finally divorced his first wife. It took that long because he had to find her. And anyone who filed for a divorce, well, this does become a problem a lot. If you can't locate your spouse to divorce him or her, first you have to go through this whole process of trying to serve them, and then service by publication. It gets expensive. So it just took a while until he was able to track her down. And he had already been dating a permanent resident for a number of years, but he couldn't marry her because he was waiting for the divorce. But even if he married her, it wasn't going to help him get a green card, because if you are a spouse of a permanent resident, as opposed to spouse of a U.S. citizen, spouse of a U.S. citizen, you cannot get your green card in the U.S. if you're out of status, and he was out of status. So first she had to naturalize. She had to become a U.S. citizen, so he became an immediate relative under the immigration law, and by being a, I see someone, Deval, I need your help. Deval, if you're on Instagram, and I apologize if I mispronounced your name, if you contact me privately, we could talk about your case, and I'll be happy to help. So she became a U.S. citizen in 2017. Shortly before that, we had gone back and forth at the court, and it was very clear that, look, his asylum case wasn't particularly strong. There's a much higher burden when you file for what's called defensive asylum, which means you don't file for the asylum until you're already in proceedings. There's a much higher burden when you've waited more than a year since your entry to file. So there was all sorts of reasons that, like, bigger obstacles we had to climb in his case than in other cases. And in 2016, the Obama administration was doing something called administrative closure. They were doing it everywhere. You may have heard the term prosecutorial discretion. If you look on our Facebook page, I think it's one of our IGTV videos. It's also on YouTube. We did a what you really want to know segment on the new immigration enforcement guidelines. He's actually going to benefit from this client, from the new guidelines. And I highly recommend you go back and take a look at that to see what I'm talking about, because it's a little complicated, and I want to just stick to the case for now. So his case, the immigration judge administratively closed his case, and just shortly, that means that although he doesn't have a future court date, he's still considered in removal proceedings, so he can't travel outside the U.S. and come back, even if he had permission. At any time, his case can be recalendared, whether it's by the Department of Homeland Security. That will happen if you, for example, get arrested for something, or by him if he then became eligible for some type of relief from removal. But by having it admin closed, it allowed him to stay in the country, and he was able to renew his work permit and continue to work legally. So after his wife naturalized, she then filed the I-130 petition, the marriage petition for him. And that was in 2018. And it's not that one, there's a higher burden now too. That one's not an easy one. Why? Again, he's in removal proceedings. If you get married or file for a marriage petition after you've been put into immigration court, then your burden, instead of it being basically more likely than not preponderance of the evidence, you're looking at a clear and convincing evidence. There's they have to believe you even more. And you also do have to go through another Stokes interview. That would be your first, not your second interview. And in this case, the other issues we had is that both of them have been previously married, which again is fine. I believe his wife was divorced, her first husband, in like 2009. And even though he only divorced his ex-wife, about a year before their marriage. Again, they had been separated for a while, and that was documented. But we still had to make sure that we had plenty of good marriage evidence to submit. So what we did was they had a child together, so a daughter. We submitted her birth certificate showing their names. That's always the best piece of evidence you could possibly have. We then had a joint lease, joint checking account, joint credit cards, and affidavits. This was in 2018. We hear nothing, absolutely nothing, until September 2020. We get a request for more evidence of their good faith marriage. So we gave more joint bank account statements, joint taxes, another joint lease, a joint loan account, joint vehicle and registration and insurance, a joint utility bill, and photos. So we felt pretty good about that. We submitted it pretty quickly. We got it in July 2020, we replied in September. They quickly replied to us after they received our reply, sending us a second request for evidence, which was quite frustrating, and that was in October. Apparently, somewhere something they had written, there was a mistake that referred to their child as their son lived with them, not their daughter. So they said, you have a daughter together, not a son. You need to explain this. Well, what happened is that my client had child from a previous relationship who lives with them, and it was just a mistake. They wrote son instead of daughter. Both kids live with them. So we wrote that back, sent that back right away, and then we finally got the approval this week. So the I-130, like I said, there was a lot that we had to overcome because we were in removal proceedings when they got married, because they both had previous marriages, and my client, his previous marriage ended in being abandoned by his spouse, which doesn't mean that the relationship wasn't real, but there's no fraud finding, but it's definitely something he had to explain at the interview, like what happened. So although it's been a long time and he finally got the I-130 approved, he does not have a green card, and his journey is not ending. And the reason I wanted to talk about this case before the real end of the journey is because of the new immigration enforcement guidelines that came out that we spoke about last week, that this is a good case to show you an example of. So when he came to us, Trump was president. And we said to him, look, you can file the I-130 even though your case is closed, but even if it gets approved, they're not recalendaring cases to let people get green cards. They're not terminating to let people get green cards. It doesn't expire the approval, but this isn't the best time to have to be in immigration court. So he understood and said he wants to have the approved I-130, and whenever is a good time for him to go back to court or to terminate, he will do that. And we had a bunch of people, a lot of clients that did that. So, because back then they did this a lot, the admin close. And it looks like they're going to be doing that a lot more now. And for people who have an admin closure that now have some type of relief from removal, this would be a good time now to start thinking about filing motions or getting an attorney to review your case. So our next step with him is going to be filing a motion to terminate and or recalendar and or adjudicate on the merits. And what that means is that we're going to file a copy of the green card application, all the eligibility evidence, show the judge, show Department of Homeland Security that he's eligible, he's a lovely wife and child together, and we want to get his case at the court and a green card in his hand as soon as possible. And there's a chance they might, if we get the Department of Homeland Security to sign off on it, which his case, he has no criminal history, nothing real negative in his case, I don't see why they won't, then we will be able to ask them to terminate, recalendar in the alternative. I think that is, sorry, Aaron's not in the office this week, so everything I'm a little nuts about. But I'm wrapping up here. So basically, we filed the motion, they said to terminate, recalendar, adjudicate on the merits. ideally adjudicate on the merits. The judge would say, oh, he's eligible, here's your green card, approved. I think it's most likely going to get terminated. Case will be sent back to USCIS, and that's where he will have his green card interview and get his green card. In the worst case scenario, they'll put his court case back on the calendar and he'll have to wait for an individual hearing with the judge, which, especially in New York, may be years and years out. So I know that they're trying to stay away from that. I'm pretty confident that we're going to get it terminated, possibly get his decision without the termination, or I should say, it gets the judge takes it back, kind of recalendars the case, grants it, and sends the order without court, without USCIS interview, maybe, but most likely terminate. So that was a lot, but that is all today for notable approvals. Like I said, check out the What You Really Want to Know episode on can I get my immigration court, I think it was reopened or terminated, I called it. If you have any questions about your own case, or our contact information has been scrolling on Facebook, has been scrolling across the bottom of our screen. If you're on YouTube or Instagram, send me a message or email me, and we'll be happy to help you. Don't forget to like us and follow us on Facebook and YouTube and Instagram, and share this video if you think you know someone who might find it helpful or you found it helpful. And finally, don't forget to tune in tomorrow night, 9 p.m. Eastern Time. We will be having episode 9 of Are You Smarter Than a Naturalized Citizen? It's a great show to watch, especially if you or someone you know is studying for the test right now, or if you're just generally interested on what questions are asked for people who are trying to become U.S. citizens. Thank you all for watching, and have a great day.